Hi, I'm Kaye Dent with Dent Coulson Elder Law, here with an Elder Law Minute for you. These videos are intended to educate you about the elder care journey, which begins earlier in life than you might think. We hope that you find them useful, and if you have further questions, please call us at Dent Coulson Elder Law. Today, I want to chat with you about how long to keep records, and in particular, in the case of a probate. If you've been the executor in a probate matter, you've probably accumulated a lot of documents. And the answer, as it so often is from attorneys, is, well, it depends. And in the case of a probate matter, it really depends on what the documents are. A lot of the documents that you'll have might be pleadings, in other words, documents which were filed in the court matter. Those documents are always going to be available from the court, and I feel pretty confident about shredding those immediately because they're probably not documents that you're going to need. And if you do, you can always get copies from the court for a very low fee, and usually pretty quickly within a day or two in most cases. That may vary from court to court. I can't speak for any particular court, but they are held somewhere for a very long time and longer than you'll probably ever need them. In another Elder Law Minute, we talked about letters of office, and those are documents that you sometimes do need in their original form, but they can always be reissued by a court. And more importantly, once the probate is closed, the letters of office are no longer usable, they're void. The executor no longer has any power, so you can shred your letters of office. Now, along the way, you might have obtained copies of the deceased, or what we call in the probate, the decedent's bank records, things like that. Obviously, you want to have those in a secure place. If you have, and I think most lay people don't have a secure server where they can keep them, but it may be that the attorney has kept those in a secure place. You can ask the attorney, because if you've handled a probate, you've probably had an attorney. So a lot of those kind of things are probably in the attorney's secure file. And if you want to keep them on hand in a very secure place for reference in case somebody has a question in the next few years, I would keep them for at least 3 years if you decide to. Again, just make sure they're secure. You might have some original documents in the forms of deeds, title work, things like that. Those kind of documents I'd keep for a longer period of time, and I'm thinking in the 3 to 7 year range for those. And if you have any tax documents, we always recommend keeping those for 7 years. Technically, your CPA or the attorney might also have those documents, but if you want to keep them on hand, the key is always keep them securely. And if you haven't guessed already, a lot of these documents are kept by somebody else in a secure fashion, and you may not need them. The only thing I would urge about is speak to the attorney for the estate about deeds and title work and other original documents that you may have the only original of. You may well want to make sure that you keep, for instance, one original, or if they're going to be secure in a safe anyway, keep any original death certificates that you have left. But I wouldn't keep anything for less than 3 years if you're going to keep it. And with tax matters, technically, if an amended return has to be filed, usually that has to be done within 3 years, but I always keep tax records for 7 years. If you need any further information on this, again, if you're still in touch with the attorney for the estate, that's the person to ask in more detail. And of course, if you're not in touch and something comes up after a probate is closed, we here at Dent Coulson Elder Law are here to help. Thank you.